Someone make it make sense.
Probably a couple.
Hello, everybody. How are y'all doing? Let me know if you can hear me and see me. I just got this set up real quickly, so I'm hoping that I have all my settings on normal. I'm trying to, hopefully I made it public. Let me see real quick. Just to make sure. It should be, okay, cool. Should be okay. Should be okay. Should be okay. So, wow. So we have a lot of things. We have all the things. So this shouldn't be too long of a live stream. I just wanted to cover these documents because we have a lot going on, in the world of law. So, one of the things is that I was planning initially on covering, tonight, the next, or I think it would actually be the last batch, but part 5 of the motions in limine for Idaho v. Koberger. However, turns out that all of these Karen Reed motions in limine are coming fast and furious. That's what she said, are coming out. And I've got a bunch of them. So I moved that, and tonight we're going to do Karen Reed, and we're going to go through, I think all the motions in limine so far are from the defense. I wouldn't be surprised if something changes by the time we go live, because those deadlines are coming right up. We could have, more motions from the defense. We could have some of the Commonwealth motions in limine, but I already have a lot of them. I think there's at least 4 or 5. So we are going to be going through those tonight, and then I may have it redirect you guys into a surprise live stream. Also, big news is that Lori Bella had a hearing today, pro se, and I am in the process of creating a thumbnail for that, so we can cover that hearing as well. It's not long, but it is very exciting because she actually has to argue to the court. It's actually, again, it's dealing with motions in limine. So she's trying to be able to get certain statements in, I think from her daughter and from her brother, both of whom are deceased, and they're hearsay. And so Lori has to argue hearsay exceptions to the court. I only saw a quick snippet of it, but I was like, yes, we need to cover this because she's actually having to argue substantial, like this is a big deal, right? It's a motion in limine from the state, and it is hearsay, and these statements could help her theory of the case, and she's having to actually argue them. And the court is not just like, sure, whatever you say. He's like, well, and so anyway, it's awesome. It's awesome. So it's going to be totally worth watching. So I'm getting that thumbnail put together so that we can watch that as well. Also, I have some exciting news for our members. I have a fun idea. Y'all let me know what you think, but I have a fun idea for what would be our first members only live stream. My plan is to set up so we can do a trivia, and shout out to Too Fast for Fleas, who had this idea about doing a trivia game. And I was like, that would be really fun. So I'm setting it up to do like legal trivia, and we could do other trivia nights with other themes, but this just seemed like a really good way to start. So I'm getting that put together so that we can do a trivia night for our first members only live stream. Now, don't worry, those of you guys who wanted to do an Orchid live stream with Q&A and whatnot, we can still do that, right? But I thought this would be really fun too. We can do whatever we want, right? So I thought this would be really fun because not everybody has orchids. So that is also something I'm getting in the works of setting up. And then I think the last thing here is that I have a couple new clips put together from recent Karen Reed hearings. So I've got a couple of those. These are short, but here's the first one. Well, actually, first of all, we need to see this to set the scene. So let me play this one.
There's no evidence of anything in this case.
Okay, so now that's an old one. Now here's one of the new ones.
They don't even have evidence, let alone a preponderance of the evidence.
And then here's the other new one.
Hard as a rock, freeze-thaw effects on penetrometer resistance. His head's as hard as a rock.
Penetrometer. Hard as a rock. Let's watch that one.
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
So could definitely go with some blunt force trauma as well there. Hi, Candace. Welcome. Happy to see you. Hopefully you heard the good news about the members only live stream idea I have for our first members only live. So that'll probably be sometime this week. And yeah, so lots of exciting things. Again, we're going to be doing Karen Reed tonight. I'm getting the Lori Vallow hearing already happened, but I'm just trying to get a thumbnail put together. I didn't even realize her trial starts so soon. It's like at the end of this month. It's like insane. Oh my God. So, and then we might also have a redirect tonight after Karen Reed into something else that will be kind of a surprise. So due to the fact that I've been talking about wanting to follow up with these documents after the most recent Donna Adelson hearing, and given that there's so much other stuff now that I'm trying to get set up, and also that this shouldn't take too long to go through these, I wanted to go ahead and cover these so that we can kind of get some of this other stuff going as well. So here we are. So this is after, gosh, I think it was last week, Donna Adelson's hearing. So we've got why is it not? Okay, here we go. So we've got two recent filings here, okay, that just came out subsequent to that hearing. Well, these, I guess, were on from the 3rd of March. So you remember she was asking for bond, but she was also asking the court to suppress the so-called hot mic video, right? Where she says she's fleeing she doesn't say Vietnam specifically in that particular call. She does in other calls, but she says, we're leaving the country. So no surprise here, but let's read what Judge Everett said here on the record for it. So this is first the motion to suppress. So the hearing was on February 26th. The arguments of parties, defendant's supplemental memorandum of law, the court file, and otherwise being fully advised on the premises, fines, and adjudges as follows. So, okay, background. On November 7th, 2023, defendant received a phone call from the Leon County Jail to her cellular phone while she was at home in her apartment. The caller was her son, Charles Adelson. At the time, Charles was an inmate of the Leon County Jail, incarcerated there since his arrest on April 21st, 2022. 1 day prior to the phone call issue, Charles Adelson was convicted of first-degree murder. 1 day before. Conspiracy to commit murder and solicitation to commit murder. Before being permitted to speak with her son, the defendant was required to acknowledge the following message and consent to its terms. The message disclosed. Hello, this is a prepaid collect call from Charlie, an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To repeat, thank you for using Securus. You may start the conversation now. So that was my attempt to sound like one of those automated people. How'd I do, guys? What do you think? I've heard that message, that specific message, enough to where I feel like it's probably pretty accurate, hopefully. Okay, this preamble is the standard notification advising individuals who receive phone calls from Leon County Jail that the calls will be recorded. Thus, to speak with a Leon County Jail inmate through this phone system, the non-inmate must give consent to being recorded unless it is a private call. Defendant concedes she was informed of this notification when she consented to speak with her son on the recorded line. Approximately 8 minutes into the call, Charles Adelson was disconnected, leaving only defendant's phone still being recorded by the Securus phone system. At that point, defendant said, "Can you hear me, Charlie? Shit, can you hear me? Again, or you can't hear me again, right? Charlie? This is actually important because it was also discussed in the hearing, but the part about again, because this happened regularly with their phone calls, and it shows that there was a difference that Donna knows how to hang up the phone, right? It's not like she's never used a phone before, because the other times this happens, she hangs up and then they start a new call or whatever, right? So I think that's, and I don't know if he'll mention that here, but I think that was part of why not that they tried to argue she's never used a phone, she doesn't know how to hang up, right? But even if they did, that could be disputed because of the fact that she hung up on the other ones. So you can't hear me again, Charlie, you can't hear me. I'm sorry. The fourth time that they cut the line each time. So Candace is saying, yeah, I used to read. Candace has been here, by the way, forever. One of the OG squirrels. So shout out to Candace. I used to read filings by myself and drive my family crazy, telling them stuff they didn't care about. I'm so glad I found you. Very happy to be a squirrel. Well, we're happy you're here. And I think, was it probably during Depp v. Heard, if I remember, because I remember the sidebars, right? I think that was the first thing I did on here, right? So Candace, again, one of the for real OG scrolls here. So she then began a lengthy conversation with other people who were inside of her home. Footnote 1. Those people were her husband, her attorney for her estate planning, because they were leaving, Susan Brotman, and Miss Brotman's husband, Richard Chagrin. And of course, he's not. Right, here we go. Defendant testified that he's not an attorney, so that you waive third party with attorney-client privilege because you have a third party there. While the issue of privilege is not raised through this motion, a recognized privilege can be waived by voluntary disclosure or consent. Right. So if you've got another person present who's not an attorney, then that attorney-client privilege is waived. Given that the defendant was conversing with people other than her son, referring to her son as he and him while talking about him and revealing facts that she did not have the heart to tell him. Remember, like I said, right? He had no idea. She was acting like they were to come visit him. It's just disgusting and sad. What's really funny is I've listened to that call a bunch of times, and I've heard her say something, tell him. I did not know until right now, because I guess Judge Everett's probably heard maybe a clarified version or whatever. I couldn't make out on all the times I've listened to it that what she was saying was, I don't have the heart to tell him. So when she says something, tell him, I didn't know what she was talking about. She could have been talking about anything. So this is news to me that is her. So, okay, let me back up. So I knew that she was keeping this from him because of context clues, right? Because of how she's like saying they're going to come visit him, But this is the first time that I've seen it in writing, because I couldn't hear this on the call, that she is actually saying to somebody else, like it's confirming what I already thought to be true, right? That she doesn't have the heart to tell him, Charlie. Fuck. The court is convinced defendant subjectively believed their shared phone call had ended and any ensuing conversations private. Subsequently, over the next 15 minutes, defendant alluded to committing suicide, professed she was looking for countries that did not have extradition agreements with the United States, wondered whether Vietnam has an extradition agreement with the United States. Right. So again, she doesn't mention Vietnam, but when she says we're leaving the country, she doesn't say we're leaving to Vietnam, but she mentions Vietnam right before that, right? We've listened to it. So wondered whether Vietnam has an extradition agreement with the United States, and spoke about a conversation she had with her daughter, Wendy Adelson, aka Fievel, and giving her papers and wills. Eventually, someone other than the defendant realized the call had yet to end and ended the call. It was only at this point that the phone call terminated and the recording stopped. Investigator Jason Newland testified, this is standard protocol for phone calls originating from the Leon County Jail. Defendant argues it was an unlawful, warrantless interception to record her conversation with Charles Adelson that was disconnected. Sorry, let me read this again. Defendant argues it was an unlawful, warrantless interception to record her conversation after Charles Adelson was disconnected because she believed the phone call and recording had ended. Analysis. Before a trial court will consider the merits of a Fourth Amendment motion to suppress, the defendant must first establish a factual basis justifying his or her claim to have possessed a Fourth Amendment right. Regarding oral communications, quote, for an oral conversation to be protected under 934.03, the speaker must have an actual subjective expectation of privacy along with a societal recognition that the expectation is reasonable. Accordingly, to successfully claim the protection afforded by the Fourth Amendment, a defendant must demonstrate that he or she personally has an expectation of privacy and that this expectation is reasonable. Defendant argued in her written motion that the state bears the burden of justifying its alleged warrantless interception. Incorrect. And moved to suppress the oral communications she uttered after Charles Adelson was disconnected from the phone call. However, the written motion misstated the burden of proof. Keep reading, Chelsea. What did I just say? Because a Fourth Amendment search does not occur even when the explicitly protected location of a house is concerned. Wait, of a house? Of a house? Of a house?
It's a house.
Hi, Black Witter. Welcome. Happy to see you as always. So of a house is concerned unless the individual manifested a subjective expectation of privacy in the object of the challenged search, and society is willing to recognize that expectation as reasonable. As a result, it is the defendant who must first establish a search occurred within the meaning of the Fourth Amendment. Therefore, to support a suppression of a communication under the wiretap law, the person who made the statement, and that's in italics, okay, must show that. So in other words, that was her burden to show, okay, not the state's burden. More than a subjective expectation of privacy, they must show that they have a reasonable expectation of privacy under the circumstances, which depends on one's actual subjective expectation of privacy, as well as whether society is prepared to recognize that expectation is reasonable. Some of that languaging might sound familiar to you guys from the BK hearings. Because the court concluded defendant did subjectively expect her conversation was private, this motion turns on whether society is prepared or willing to recognize such subjective expectation as reasonable. Really interesting, and he's articulating this very well. I will say that this was not as clearly laid out, I feel like, in the hearing. However, the audio was also really, really, really bad. But basically, what he's saying here is like, and I appreciate it. He laid out earlier that we just read how Donna did think her call had ended, right? Because of the fact that so in other words, because we talked a lot about this, right? Did she know the call was ended? Blah, blah. Because he says of the way that she spoke about Charlie in the third person, and then also said the thing about no, didn't have the heart to tell him. He's saying she thought her call had ended, basically, right? In other words, she did have an expectation that her conversation was private. So he's conceding that, right? But what he's saying is this motion turns on whether society is prepared or willing to willing to recognize such subjective expectation is reasonable. After conducting a thorough analysis, the court has determined defendant's conversation did not constitute the unlawful interception of an oral communication. So let's see what he says. So reasonable security measures of Leon County Jail. To ascertain whether society is prepared or willing to recognize defendant's subjective expectation of privacy as reasonable, the court begins with the well-established principle that citizens are guaranteed a reasonable expectation of privacy in their own home. The court also recognizes that jails and correctional facilities have a strong interest in preserving and maintaining their security, and the interception of calls from inmates to non-inmates does not violate the privacy rights of the non-inmates. And then here's another footnote. So at the hearing, defendant concedes she bears the initial burden of establishing a subjective expectation of privacy that society is prepared to recognize as reasonable. Following the court's finding that defendant established a subjective expectation of privacy, the court remarked that the burden shifted to the state to establish society would not recognize her expectation as reasonable. Upon further review of the relevant precedent, the court concludes defendant also bears the burden of establishing society would be willing or prepared to recognize her subjective expectation was reasonable. Both parties were permitted to argue the issue of whether the subjective expectation of privacy was reasonable during the hearing. Okay. So then he's citing here from this other case law here, right, because of society has right. So they're saying the interest in institutional security allows jails because society has an interest there, right? In addition, it does not matter whether the call is made to a non-inmate's home. Thus, defendant relinquished her reasonable expectation of privacy when she answered her phone and consented to speak with her son. Defendant argues she regained a reasonable expectation of privacy previously relinquished through consent once her son was disconnected. Okay, that's how she was trying to get around that, right? Okay, so once Charlie was disconnected, she's saying now that the expectation is different. It should go back to as if it wasn't from a jail call. Nah. All right, a reasonable expectation previously relinquished through consent once her son was disconnected, right? But she did not actually terminate the phone call from her end. During the hearing, the state contended that the primary basis for denying defendant's motion to suppress was that it did not intentionally record defendant's conversation, footnote 3. The state also argued defendant did not have a reasonable expectation of privacy, arguing that the reasonable expectation only begins once a person actually hangs up the phone. The court disagrees with the state. Interesting. The Leon County Jail intentionally utilizes technology developed by the company Securus that, by design, continues to record conversations between inmates and call recipients until both parties disconnect. That was not made clear from my view in the hearing. And again, the audio was terrible. That could have been part of it. This is really fucking important, right? Because I was not able to glean that from the hearing. So, and again, it wasn't in the court filings, which we read the pleadings, right? So this is from Judge Everett. He disagrees with the state because the state said the primary basis that they were saying the court should deny the motion to suppress is because it did not intentionally record the defendant's conversation. What he's saying is this. He's saying that the Leon County Jail intentionally uses technology that continues to record both inmates and both parties, right? The inmates and the call recipients until both parties disconnect. That's very interesting and important to know, right? So in other words, this was not a fluke. This is standard protocol. If the decision to record prior to the inmate's disconnect is intentional, as the state's argument concedes, it stands to reason the decision to record after the inmate is disconnected is also intentional. However, in determining whether an expectation of privacy is reasonable, courts should examine the location of the conversation, the type of communication at issue, and the manner in which the communication was made. Although the location of the defendant's conversation occurred within her home after her son was disconnected, the fact remains she consented to receiving a phone call from a jail facility. The type and manner of the communication are also quite different from ordinary phone calls. This phone call, 1, began with a message stating it was not private. 2, required acknowledgement that it was being recorded. 3, required consent to proceed. And 4, utilized third-party technology to facilitate recordings between inmates and non-inmates. Even if many modern cellular phone devices typically terminate a phone call when one party is disconnected, as defendant stresses, communications from jails and correctional facilities have unique institutional safety concerns that are not at issue in common communications between non-inmates. And why does this matter? Remember, it's the societal expectation of privacy, right? That's what this is going to, as to why it's different with an institution and why the institution continues to record unless and until both parties hang up. Thus, defendant's subjective expectation was built on a false assumption that dropped calls involving the Leon County Jail have the same result as dropped calls involving at least one cellular phone. I'm going to read that again. This is really, really, really important. Again, the state did not really make this clear, but Judge Everett surely is. This is a very well-written ruling that lays this out in a way that makes complete sense. This makes complete sense. Thank you, Judge Everett. So I'm going to read this again. Thus, defendant's subjective expectation was built on a false assumption that dropped calls involving the Leon County Jail have the same result as dropped calls involving at least one cellular phone. There's a footnote. Footnote says, on this point, defendant's hearing testimony was inconsistent, where she acknowledged a belief that calls from the Leon County Jail end whenever an inmate is disconnected. She did say that. I remember her saying that, while also admitting she hung up her phone each time Charles Adelson was previously disconnected before November 7th. And I actually mentioned that as well. Was I clapping? I might have been clapping. If I was clapping, it's because I was thanking Judge Everett for making this clear. Whether defendant forgot to hang up her phone or assumed it was unnecessary, society would be unwilling to recognize her expectation of privacy was reasonable. I'm going to read this again because he's basically calling her out on contradicting herself. And that's awesome. So let's read this again. On this point, defendant's hearing testimony was inconsistent, where she acknowledged a belief that calls from Leon County Jail end when an inmate is disconnected, while also admitting she hung up her phone each time Charlie was previously disconnected before November 7th. Whether defendant forgot to hang up her phone or assumed it was unnecessary, society would be unwilling to recognize her expectation of privacy was reasonable under either circumstance. This is a really, really well written. I freaking love this. Way to go, Judge Everett. Way to go. Way to go. Oh my God, I can't type. Okay. So that's the footnote we just read. So this assumption is unreasonable given the concerns correctional institutions and jails encounter. Again, going back to that societal, what does society view and what do they expect for reasonable, to be reasonable, right? When it comes to privacy, the societal concerns. So for example, a federal court of appeals has remarked that the Bureau of Prisons recording system and random live monitoring of telephone conversations have assisted in the detection of escape plans, of schemes to smuggle controlled substances into the facility, and of inmate identification of another inmate as an informant in the government's witness protection program. There is no plausible reason why the Leon County Jail should not be afforded deference in how it uses a recording system to safeguard against similar security concerns, including by continuing to record an inmate's phone call until both parties have disconnected the phone call. And then there's another reference here to this case law, U.S. Supreme Court case law. Prison officials must be free to take appropriate action to ensure the safety of inmates and corrections personnel and to prevent escape or unauthorized entry accordingly. So this is a good point. And let me explain why I think this is a good point. Because remember, the whole thing about the Leon County Jail, their system is going to continue to record until both parties end the call, which distinguishes it from cell phones, right? But this makes sense. And here's why. Because if you've got a phone call from an inmate to a family member, and let's just say that somebody is going to, or a friend or whatever, let's just say that somebody on the outside is going to help them attempt to smuggle in drugs or help them escape. You can see why this is important for safety. And I had not thought of this until Judge Everett put this in this pleading. This makes complete sense. That's why it's different. because you could have friends or family members who are going to assist the inmate, right, in something that is unlawful. Unauthorized entry or escape. I would say society definitely has a reason to not want that to happen, right? So yeah, okay. Accordingly, we have held that even when an institutional restriction infringes a specific constitutional guarantee, the practice must be evaluated in the light of the central objective of prison administration, safeguarding institutional security. Security risks do not dissipate when only the inmate disconnects the phone call. In the ever-evolving technological world, inmates and non-inmates can exploit loopholes to circumvent institutional safeguards. And as federal courts have opined, it is difficult to imagine that the considerations that justify monitoring and recording of a prisoner's utterances could somehow not apply at the other end of the telephone. Right. For the reasons I just gave, right? The rights of free persons may well at times be implicated and stand and fall with the rights of the prisoners. Yep. It makes sense. Defendant's subjective expectation conflicts with her own knowledge. Yes, you tell her, Judge Everett. Charles Adelson was arrested on April 21st, 2022. The portion of the conversation defendant seeks to suppress occurred on November 7th, 2023. That period spans a difference of 565 days. Based on the sheer volume of calls, and then there's a footnote. Investigator Newland estimated there were thousands of calls between the defendant and her son while he was incarcerated at the Leon County. Yeah, and we've heard a lot of them. Based on the sheer volume of calls between the defendant and Charles Adelson, right? Because of course, see now Donna's the defendant now, and Charles Adelson, she cannot reasonably claim to have been unfamiliar with how the Leon County Jail facilitates phone calls from inmates. This assertive subjective expectation became less and less reasonable with each time she answered a phone call from the Leon County Jail, consenting to recorded calls until both parties are disconnected. She cannot even claim to be unfamiliar with what transpires when a Leon County's inmate's phone is disconnected. This is what I said at the beginning of this live stream because of all the times he got disconnected. So yeah, let me read this again. She cannot even claim to be unfamiliar with what transpires when a Leon County inmate's phone is disconnected because she is heard acknowledging on the November 7th, 2023 recording that her son had been disconnected for the 4th time. Defendant testified her son was frequently disconnected during their phone calls he made from the Leon County Jail. She did. During these other instances, defendant answered she would ordinarily, quote, hang up, end quote, the phone after he was disconnected, suggesting she realized she needed to hang up the phone to end or terminate the calls. Thus, rather than expecting her phone would automatically disconnect, her own testimony reflects that she was aware that calls from Leon County Jail would continue unless and until, that's literally what I said, the unless and until part. She hung up her phone, expecting an opposite result or outcome from what was taken place previously, or what has taken place previously and repeatedly is an expectation society is unwillingly and unprepared to recognize as reasonable. This is a really I'm gonna save this like permanently. This is such a good order. This lays it out so well. I am like shocked. Like, I mean, I don't know if shocked is the right word, but like I'm just really impressed. And I've read a lot of court filings, as you guys know. I'm really impressed with this. This is really well thought out, really well laid out. It's clear, it's linear. Way to go, Judge Everett. Conclusion. For these reasons, the court cannot conclude society is prepared to recognize as reasonable defendant's subjective expectation of privacy in the November 7th, 2023 phone call. The phone call was received from a jail or correctional facility with a valid interest in preserving security by continuing to record phone calls until both parties of the call have disconnected their phones. And then 2, defendant's subjective expectation was contrary to her own familiarity with the Leon County Jail phone technology and prior user-based knowledge. And 3, expecting different outcomes or opposite results from what has repeatedly occurred is intrinsically unreasonable. It is ordered and adjudged that defendant's motion to suppress is hereby denied. You get it, Judge Everett, you get it. All right, next we are on to the second one here. This is the order denying bond. No surprise here. This cause came before the court when the defendant sought review of her bail status based upon State v. Arthur. The court, having reviewed the evidence admitted during the February 26, 2025 hearing, the arguments of the parties and the court file, and being otherwise fully advised in the premises, finds and adjudges as follows. Defendant is charged by indictment with a qualifying offense, first-degree murder, and the state has come forth with a showing that the proof of guilt is evident or the presumption is great. Proof evident or presumption great. Speaking of which, that is literally referenced in one of the new clips that we have of the proof evident and the presumption great. So let me pull that up real quick. Whee!
They don't even have evidence, let alone a preponderance of the evidence.
Well, okay, so preponderance, not presumption, but still. I love any excuse to get to watch some of these, you know? So speaking of which,
Hard as a rock, freeze thaw effects on penetrometer resistance. His head's as hard as a rock.
Shout out to Mr. Alessi for providing us with some awesome moments from those hearings, to which we now have 2 more clips we can go to. Okay, so the evidence from Charles Adelson's trial, footnote 1, the court presided over Charles Adelson's trial in Leon County and remains very familiar with the facts and evidence in the case. Yep, he knows the case very well. So wait, where did it go? Where did the footnote go? Right. Okay. Charles Adelson's trial, viewed in the light most favorable to the state, demonstrates 1, the defendant's personal and unique motive to assist, cause, or encourage the murder of Dan Markel. 2, the lengths the defendant was willing to go in the custody battle involving her grandchildren. 3, testimony by Katie McBanoa directly implicating the role of the defendant in the payment of the murder for hire. 4, payments made by the defendant to alleged co-conspirators following the murder. 5, text messages and cell tower analysis demonstrating defendant's movements on the night of the murder. Interesting. So her movements, remember how I keep saying we're going to get new information with Donna's trial, same with Wendy, that we didn't have in the other trials because it wasn't relevant. I'm so fucking excited. So excited. Because her movements, we did not have. We might have it. It sounds like we will have it in her trial. 5. Oh wait, I already read that one. And number 6, defendant's conduct after the law enforcement bump operation and communications on authorized wiretapped interceptions. Defendant also exhibited a consciousness of guilt. Yeah, she sure did. When she attempted to flee to Vietnam prior to arrest using, quote, an emergency fast track visa, end quote. You can't make this shit up, guys. The evidence of flight is admissible as consciousness of guilt where sufficient evidence exists to establish the defendant fled to avoid prosecution. After the state meets its burden regarding Arthur, the court still retains the discretion to grant or deny bail. When determining this issue, quote, the burden is on the accused to demonstrate that release of bail is appropriate. It is with regard to this question that consideration of the likelihood that the accused will flee, regardless of the sureties required, becomes appropriate, as in you're not allowed to even, we're not even going to set bond, right? In reviewing the evidence, footnote 2, dude, I love this. Judge Everett with the footnotes. The court reversed ruling at the hearing on the admission of states exhibits 4 and 5, based upon the court's ruling denying the defendant's motion to suppress filed February 10th, 2025. These exhibits are admitted over objection. So remember, because there was an overlap, right? The timing of the motion to suppress and the thing that they wanted suppressed being the hot mic phone call, wherein she announces that they're leaving the country and then also talks about Vietnam. You see what I mean? So because, in other words, what he's saying is this. Because the defense filed that motion to suppress about the hot mic phone call and they were going to be hearing it at this same hearing, essentially, these exhibits of the hot mic phone call now are admitted because it's relevant here as well. In other words, or no, sorry, hold on. No, hold on. Let me correct that. He's actually referencing the trial. Never mind. He's referencing the trial. The court's ruling denying their motion to suppress, which we just read. The exhibits are admitted over objection. So in other words, he's just including this as a side note, basically, that they're going to be allowed in. So in reviewing the evidence admitted during the hearing and applying the bail criteria of section 903.046 Florida statutes, the court finds that one of the primary considerations of bail, ensuring the appearance of the criminal defendant at subsequent proceedings, no kidding, cannot be met. One day after Charles Adelson was convicted of first-degree murder and other crimes, the defendant discussed fleeing to countries without extradition to the United States. That same day, the defendant communicated with Vietnam Visa, Indochina Sun Travel, through what she believed was a secure communication application, WhatsApp, trying to acquire a fast-track emergency visa for Vietnam and wanted it the fastest she can get it. The purchase of a one-way ticket and seeking a fast-track visa for extended stay in a country without extradition clearly demonstrates an intent to flee. The court does not find the testimony offered by the defendant during the evidentiary hearing on the subject to be credible, considering the evidence. Additionally, defendant's discussions of self-harm further negate the possibility of appearance for subsequent proceedings as directed by the court. The issues raised by the defendant concerning her conditions of confinement can be directly addressed through administrative and or civil remedies. Absolutely can. Yep. The testimony and evidence during the hearing clarify the reasonable measures taken by the Leon County Sheriff's Office to address defendant's concerns. Defendant is not being denied access to counsel or the opportunity to prepare for trial. The court also notes the defendant has undergone extensive trial preparation prior to the continuance of the trial on September 17th, 2024 through the present. In other words, she was supposed to already have gone to trial and be done already, right? Which is a great point that he's making, that the state didn't make. He's making a great point here. They were supposed to already be done. Like the trial was supposed to originally be on September 17th. That got continued to October 1st. And then because of all the attorney-client fuckery and Dan Rashbaum and all that, it was continued until June. So in other words, she clearly was fine to go to trial in September of 2024. And now by the time she goes to trial this year, assuming that date sticks, it's almost a year later. So to say she didn't have enough, she's not able to prep or whatever. Yeah. So that's a great point that he made. Well done. Well done. Well done, Judge Everett. Lays it out. This is really, 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 really great order. I mean, again, we read a lot of these, and most recently, in terms of orders from a judge, the most recent I've been reading and we've been reading is from Judge Bev. And even if you remove the bias and whatnot, I mean, like I said, I'm really impressed. This is really, 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 really thorough, linear, clear, logical. I mean, making points for both sides that the parties themselves didn't think of. You gotta love that. He made some points for the defense that they didn't think of when they argued. Same thing with the state, right? He made points for both parties that they had somehow missed, which shows the thoroughness and the thought put into it, but also how fair that is, right? So yeah, I'm going to keep these permanently and use them as examples, I think, too, in the future, because these are really, really well done. I'm really impressed. So that gets us up to speed in terms of, oh my God, the documents for Donna's case. Like I said, for anyone who missed it, we got a lot going on, guys. I'm getting that thumbnail put together for Lori Vallow's hearing, where she argued or tried to argue to the judge exceptions to the hearsay rule. And they'll be short, but it's very interesting. And then also we've got all these motions in limine for Karen Reed that are coming out. Probably there's more out since I last checked. I wouldn't be surprised. So like I said, we're going to be doing that tonight. And then probably redirect you guys into a surprise live stream. And then again, we also have looking forward to our first members only live stream where we're going to do a trivia game night with, for this first one, we're going to be doing law related trivia. And it'll be really super fun. So I'm going to get that put together. We'll probably have that this week. And I had to think about what I wanted to do. And then now I'm figuring out how to do it, but I think I've got it figured out. So that's what we will be doing. So very exciting for all of that. So again, tonight we'll be doing the Karen Reed motions in limine and probably redirect you guys into a surprise live stream. I was going to try to do the Lori Vallow hearing today, but you know how I am with the thumbnails, right? So that will probably be tomorrow, more than likely. Candace says it sounds like fun. Awesome. I'm glad you like the idea. Yeah, law trivia. It'll be super fun. And like I said, we can do other trivia themes for other nights, but also we're still going to be doing some orchid streams because I know you guys, many of you guys have orchids, and even shout out to Iowa Backyard Camp, by the way, who does not have orchids, but has been watching and commenting on all of the orchid videos. And now just because she's like, I love watching this. I love these orchids. I don't even have orchids. So, that's awesome. But like I said, it's not going to be only orchid related. So that's why I'm coming up with some other ideas, and the trivia will be fun for everybody. So definitely keep an eye out for that as well. And trying to think if there's any other updates. I feel like there's so much, but yeah, that gets us up to speed with Donna here. So yeah, so other than that, we will be back for more later. And that will be what we do. So love you guys as always. Love the Squirrel Crew, and I will be seeing you guys soon, and squirrel out.